Welcome back to Law Stash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss a California case that answers the question whether a mere presence of a legal amount of marijuana on a passenger's person establishes enough probable cause for the police to search the entire vehicle without a warrant by relying on the automobile exception. And before we go on, I want to thank you for watching me on YouTube and subscribing, hitting that bell notification button. And if you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you're interested, please go on my website at lawstash.com and purchase some of my merch. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing a California case, People v. McGee. First, let me give you some factual background. Two officers are conducting a general patrol of an area. They notice a vehicle with an expired registration, so they turn their lights on and pull over this vehicle. Mr. McGee is the driver of the vehicle, and there's also a female passenger next to him. When the officers approached the vehicle, they right away noticed an odor of marijuana. Then one of the officers, speaking to the passenger, notices an unsealed marijuana bag hidden in her cleavage. The officers then tell the driver that they're going to conduct a search of the vehicle without a warrant. He does not consent to this search, but he is cooperative. So while the defendant and the female passenger are out of the car, the officers go into the vehicle, and during their search, they see a zipped purse. They open that purse and they find a handgun. Mr. McGee later told the officers that he placed his gun in the female passenger's purse prior to being pulled over. He now says that that search violates his Fourth Amendment rights. Remember, the Fourth Amendment protects you against unreasonable searches and seizures, meaning that generally speaking, officers need to have a warrant before they conduct a search. And warrantless searches are presumed to be unreasonable. Of course, there are exceptions to the rule, and here the government relies on automobile exception. Under this exception, if the officers have probable cause to believe that a lawful stopped vehicle contains evidence of criminal activity or contraband, they may conduct a warrantless search of an area in the vehicle in which the evidence might be found. Once an officer has probable cause to search the vehicle under the automobile exception, they may conduct a probing search of compartments and containers within the vehicle whose contents are not in plain view. Moving on to the law, the court first has to answer the question whether a mere presence of a lawful amount of marijuana generates enough probable cause to search the entire vehicle for more marijuana. And to answer that question, we have to look at some statutes. First, under section 11362.1 of the Health and Safety Code, that code provides that cannabis and cannabis products involved in any way with conduct deemed lawful by this section are not contraband nor subject to seizure, and no conduct deemed lawfully by this section shall constitute the basis for detention, search, or arrest. The plain language of section 11362.1, subdivision C, indicates the legislature's intent to remove cannabis from the ranks of contraband that gives rise to probable cause searches. As such, in light of recent precedent, the people's first argument that the mere presence of a lawful amount of marijuana is sufficient to establish probable cause to search under the automobile exception is without merit. In 2019 California case People v. Lee, the court held that the defendant's lawful possession of a small amount of marijuana does not justify a probable cause search like we have under the automobile exception. I have previously discussed People v. Lee on this channel, and I encourage you to watch that video or listen to that segment on my podcast on Audible or Spotify, and I will link it in the description below. But pursuant to Lee, officers may not conduct a warrantless search under the automobile exception because a mere presence of a lawful amount of marijuana does not generate enough probable cause, unless there's another statute that's being violated. And in this case, there is. Let's remember, the passenger had marijuana in plain sight, and that marijuana was an unsealed bag. Under section 11362.3 subdivision A4, it states that while the possession of up to 28.5 grams of marijuana is now lawful pursuant to section 11362.1, it remains unlawful to possess an open container or open package of cannabis or cannabis products while driving, operating, or importantly, or riding as a passenger in a seat or compartment of a motor vehicle. And here, the passenger was driving or riding in the vehicle with an open, unsealed container of marijuana, which is a violation of this particular section. And so officers could search the vehicle, including her purse, because there's this additional violation, and that provides probable cause to search the entire vehicle, including her purse. What do you think about this case? Does this additional information, in your view, provides that probable cause or not? Leave the comment below and tell me what you think. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you're listening to my podcast on Audible or Spotify, please give it a 5-star review rating. Thanks for watching.